So explanation of wills, I put the wills in front of them. And I say that you can revoke any and all previous wills, and this is what we're doing, and that you're residents of, whatever county they're residents of. Then I show them the date of their marriage, the names of their kids, ask them if that's correct information. And then the next article, I talk to them about the personal property, and I show them the personal property memorandum in the folder, saying that they can distribute personal items through the separate writing. Just make sure that they date and sign it, and that they're specific enough that their executor, personal representative, knows what they're talking about. And then I go on to the beneficiary section, the next page, and I say everything goes to your spouse. However, that's very unlikely will happen because spouse would have predeceased you normally. So very rarely do we probate at the death of the first spouse because all of the assets were in joint names, and we would just probate at the death of the last spouse when assets are in the deceased spouse's name alone. So again, probate is about assets that are in a deceased person's name alone that does not have another owner and does not have beneficiaries named. And I'm pretty sure that this couple has beneficiaries named on all their assets, with the exception of their house. And then if the spouse should predecease, everything goes equally to their two kids per Stirpes, which I tell them that means their grandchildren, not the spouse of their child. And then we go on to name who named as personal representative, also known as executor. Make sure the names are correct, spelled right and everything. And then I just say the rest of the document is language that is going to be for the benefit of the personal representative, saying they can hire professionals, they can be compensated, which in this case they're very unlikely will be because the only asset would be the homestead. So we want to try to make sure that the only asset going through probate would be the house, which means the time involved in probate will be reduced down to several months, and then it won't cost as much. And so those are the wills. Next document would be the durable power of attorney. This is by far the most important document. This is what's going to come into play in the event you become incapacitated. And on the husbands, we have the wife with the two kids acting together, so that all three will be able to act if he becomes incapacitated. And that is a very broad powers. Show him that it's a very lengthy document, very powerful document. He needs a trust whoever you put in that role because they can do everything he can do as far as, having access to assets, is writing checks, paying bills, selling his house, which is why we do not need the kids named on the accounts as owners. So the power of attorney is going to be the document that's effective the minute it's signed, and is by far the most important estate planning document. Her power of attorney agents would be her husband, and then back up to him are the two kids. I believe it's either or. And then to show them how lengthy it is, basically saying that any power under the sun that they can think of is listed in that document based on the new change in law that took place in 2011. And then go to Article 5 where it starts talking about special powers. Show them the little boxes and say that we're recommending that they initial yes on each box, which will allow their agents to act for them. If they do not say yes, that means their spouse or their kids will not be able to make those decisions, which means they'll have to go get a guardianship set up, which is what we're trying to avoid. Power of attorney is powerful, so that's why we trust the person, because they really can do anything you can do. And unfortunately, the document is effective the minute it's signed, so you do not necessarily have to be incapacitated for the person to act, because there are some companies that will take a copy of the power of attorney and not request a document from a doctor saying you're incapacitated. So just make sure they understand that. And I give them a couple of examples from the special powers, like this person will have access to your retirement accounts, creating trust on your behalf, access to, changing beneficiary designations, annuities, changing when an asset is owned, doing Medicaid planning. So basically anything that could at some point change their estate plan, that's what they're initialing. And then we say that each agent is going to sign acceptance affidavit saying they agree to act for the spouse or their parent. So that's the power of attorneys. Next document is the HIPAA release, and that just says that it's a generic release giving access to the spouse and kids of any medical information they may need, which is basically if they need proof that you're incapacitated, or if they need a second opinion, or just to find out how mom or dad's doing in the hospital, or spouse, you need that generic release. And then we go on to the healthcare surrogate. Again, husbands is the wife and the kids acting together. Wife's is her husband and then the kids acting together. Just make sure they're okay, make sure the spellings are correct, and that they understand that the healthcare surrogate is the person who's going to make all medical decisions. So make sure that you have the conversations with your family of into life decisions, making sure they know that, you don't want to be artificially prolonged. If you want hospice care, you don't want hospice care. If you're going to get a DNR, if you want one. So the healthcare surrogate really at the end of the day is going to have the decision if you're unable to make that decision for medical decisions. And the healthcare surrogate is the one who's going to enforce the living will. The living will is basically just saying, in the event you're terminal, in stage, death is imminent, no chance of recovery, to doctors certify you meet those requirements, you're saying you don't want your life artificially prolonged. Make sure they understand that that's only what's covered in there. A living will, it does not cover everything. People put too much emphasis on it, when in essence it's very rarely put in effect. But they need to make sure everybody's on the same page for their end-of-life decisions. So example I always give them is, what if spouse or parent has dementia and they stop swallowing, and the doctor is asked, do you want to put a feeding tube in? If you put a feeding tube in, obviously you're prolonging life. If you don't, then you're ending life. And that is a decision the healthcare surrogate makes. It is not based on the living will. So again, you want to make sure the healthcare surrogate knows all of your wishes, even if it's beyond a living will. And also, if they want to go into an assisted living or spend all their money in home care or nursing home. So those are the documents. Basically, I just make sure they understand what probate is. And obviously, you can give them examples of probate. Let them know that even if there's an asset that only has, $500 in it, they still have to probate it. So we don't care what the value of the asset is. We want to make sure all of their assets have beneficiaries named with the exception of the house. And then we want to make sure that the kids, know where everything is located in your house. I don't think they need a copy at this point. They obviously know how to get in touch with me because they both came to the meeting. But they need to know where the documents are. They need to know where Dad, keeps his important information in the house. If he does stuff, bill pay online, usernames, passwords, because once he becomes incapacitated, they may not be able to get that information. So that's a quick summary. Again, it's just making sure that, at this point, these clients had all these documents, so it's just a review. And then if they want, I can go over it with them when I come back to work by the phone, or they can come back in at that point. But we wanted them to come in so that they'd have it signed just in case something happens in the meantime. Because if I have the appendix removed, I'll be out for at least a week. So, okay.